Hello, my name is Conor Duff and I am the FE1 EU Law lecturer here at City Colleges. This is a short video designed to prepare you and provide you with last minute tips for your upcoming FE1 EU Law exam. This lecture is also supplemented by some very short revision notes for your night before the exam to assist you for the last minute revision for the EU Law exam paper itself. Thankfully, EU law is a very nice subject for the FE1s. For those of you who have looked over the past papers, you will note that the topics can be somewhat predictable, that it is clear from the examiner's reports that he's really just looking to see that students have a solid understanding of EU law and that they are able to advise the individuals in the problem questions in a really clear and comprehensible manner. So, in terms of the challenges associated with FE1 EU law, I have it here, and this is something that I always say to students at the beginning of the course, that EU law is a non-traditional law subject. So we're used, for those of you who have done other FE1 exams, you will be used to kind of learning principles and then learning cases and how the cases have developed the principle. With EU law, it's really important that students emphasize in their exam script the importance of the treaty provisions. And I always would start your discussion of the law for this exam by reference to the salient portions of the treaty provision itself. So students really need to hone in on the wording of the treaty provisions and to identify the salient aspects of each treaty provision relevant to each question on the exam paper. It is known by all of you at this stage that there is quite a broad amount of material that you're expected to know for this exam, particularly the larger chapters such as competition law, such as the free movement of goods, the free movement of persons, etc. So there are very, very chunky topics for this subject, but as you will see through the past papers, there are really only aspects of each of those topics that are highly examinable in this exam. I also have here another challenge, is that the legislative sources can cause difficulty for students in this exam, and that is why it's really important that you are not leaving it till the night before the exam or the morning of the exam to familiarise yourselves with the treaties. You really need to go through the treaties text in advance of the exam to ensure that you're familiar with it, you know your way around it, and you're able to identify quite quickly where the treaty provision is that you're looking for. So you should really take some time now before the exam to familiarise yourselves with the treaty text. In terms of the EU law paper itself, as you will know, there's a mix between essay and problem-based questions. And then question 7 is typically the case note question, where you're presented with, I think, 7 cases or 6 cases, of which you need to write a case note on 3 of those cases. Now, I typically advise my students to avoid the case note question because it is very, very difficult to obtain the amount of marks necessary to do really, really well in the question. So if possible, I would prioritise the problem-based scenarios and the essay-style questions. Just in terms of the permitted legislative sources for the exams, so you can of course bring in a consolidated version of the treaties. There is the text that I edited with Dr. Anthony Walsh and with Claris Press that you can bring into the exam, or you can bring in Blackstone's treaties. You should really ensure that you familiarise yourselves with it, you can tabulate it, you can highlight, underline the relevant portions of the treaty provisions in advance of the exam so that you're prepared for the questions. In terms of the predictable topics that are very, very popular in your exam, you will see when you go through the past paper questions that there is some level of predictability with the topics that can come up. Although in some of the papers, the examiner will usually put one question that wouldn't be predicted in earlier papers. And we saw there a couple of papers ago, the examiner was leaving out certain topics that would have traditionally been very, very predictable. So direct effective directives was left out of one paper. I think the free movement of persons was left out of another paper. But nevertheless, there are some still really strong topics that come up in all of the papers that we see time and time again that are really, really predictable, and students will need to know these topics really, really well for their exam. So the free movement of goods, again, has come up in every single paper with this examiner, and I usually break that down into 2 chapters for the students. The first chapter that I look at is articles 34, 35 and 36. This is in respect of quantitative restrictions and measures having an equivalent effect to a quantitative restriction. So I deal with that firstly, and students are very, very familiar with that topic. Your Dassenville formula, your key case law that you need to know for quantitative restrictions and MEQ wars. The second chapter that I look at for free movement of goods are articles 30 and 110. 30 obviously dealing with customs duties and charges having an equivalent effect to a customs duty, and then article 110, which deals with discriminatory internal taxation. General principles of EU law and fundamental rights, again, very, very predictable. The general principles of EU law can be examined in a number of ways, typically as to how it protects individuals, EU institutions and member states when implementing EU law. And then fundamental rights, again, a very, very popular topic, has been examined in a number of ways, either asking students to discuss the development of fundamental rights since the 1950s, or discussing perhaps the Charter, the EU Charter of Fundamental Rights, the EU CFR and its development, and students tend to be very, very well prepared for those questions on the fundamental rights. Competition law, again, has been relatively popular. The question on agreement, concerted practice and decisions is a very popular question. Merger control hasn't come up for some time. Sometimes the examiner will ask A, which is on competition law, or B, which is on merger control. So that's again a very popular topic. Free movement of persons, again another topic that has been up in every single paper except for one, I think, a couple of papers ago. And again, students will be very prepared for that. Judicial review is another very, very popular topic, traditionally examined by way of an essay question, although it has come up by way of a problem question in some papers about annulment. And the question tends to focus on the standing requirements for non-privileged applicants and how it was affected by the Lisbon Treaty. So students would start off with the position pre-Lisbon, where they would discuss ploughman, then they would, and other related cases, Front National, Paraki Petraki, there's lots of case law there. Then moving to the impact of the Lisbon Treaty for non-privileged applicants, which removed the requirement for individual concern for EU legislative provisions not requiring an implementing measure. And then you would deal with the effect after Lisbon, and you would look at cases such as IBM, Microban, Pfizer, etc. So again, that's a very, very popular question. Students are usually given a quote by Advocate General Jacobs in UPA and the Council, where he is quite critical of the ploughman standard. And then of course there's Diego Quer, where the General Court was quite critical and tried to bring in a link with the charter rights, which was unsuccessful before the Court of Justice. But that question is very, very popular. But don't be afraid if it does come up by way of a problem question, because it has in the past and probably will in the future. Institutions then usually comes up and is examined with sources of EU law, and students are asked to discuss the role of the various institutions and their role in lawmaking. So students will be talking about the ordinary legislative procedure and the special legislative procedure, which is comprised of the consent procedure and the consultation procedure. And then again, the very, very popular topic, which is the direct effect of directives, which is usually examined with a little bit of indirect effect if students put it in, and member state liability. And again, that's come up in every single paper except for one, I think, in recent times. So these are really the banker topics that students expect to come up in the EU law exam. So over the next set of slides, I go through the recently examined topics. In the March 2024 paper, you saw direct effect of member state liability, fundamental rights, sources of EU law, free movement of persons, free movement of goods, judicial review, the case note question, which is always question 7, and then competition law. Now, there was the kind of odd question that came up in October 2023, question 6, which was a question on state aid, and I think that's one of the very first in a long time for that topic to be examined, and I don't imagine it was a very popular topic, but it could very well arise again for your upcoming paper. So the slides there that you can look at in your own time in terms of the previously examined papers. And I then focus again on structure, which is really important. The ILAC structure, issue, law, application, conclusion, to be used for problem-based questions. And don't forget to apply the law to the facts of the problem question. So I go through some of the past paper questions here. This is the March 2024 paper. This is just for your own revision. Question 1 here, again, this was a very, very popular question which examined students on the direct effect of a directive and member state liability. Question 2 was asking you to discuss the development of human rights since the 1950s, and again, students would have been very, very prepared for that question, where you start off with the relative silence in the treaties, then to a predominant focus on fundamental rights jurisprudence coming from the Court of Justice. Question 3 was on the ordinary legislative procedure. Again, tricky enough question. Don't imagine it was that popular, but it was relatively straightforward. Question 4 then was on the free movement of persons. You're asked to advise Carlos, an Argentinian national. So again, no surprises there. Students would have been very, very well prepared for that question. Ample reference to the Citizenship Directive. Question 5 then was on the free movement of goods, and in particular this concerned quantitative restrictions and measures having an equivalent effect to a quantitative restriction. And again, students would have been very well prepared for that topic. Question 6 was on the, again, standing requirements for non-privileged applicants in judicial review. And then question 8 was asking you to discuss the concepts of agreement, decision, and concerted practice for the purposes of 101, and then to explain what a dominant position is for 102. In terms of my predictions, I go back to that slide that we looked at already, which are the highly predictable or popular topics. I wouldn't be surprised to see a free movement of services question come up in your exam. There's been a few in the past in terms of access to healthcare. So I, again, wouldn't be surprised to see that arise with the free movement of goods, fundamental rights, perhaps a question on the Charter, competition law or merger control, the free movement of persons, judicial review, institutions, and direct effect directives. So I know that was a whistle-stop tour of some of the highly examinable topics. It's really important that students familiarise themselves with the past paper questions for this topic, because you will see the trends that arise in the papers. So thank you all very much for your attention. I hope you found this video to be helpful and useful for your upcoming FE1 EU Law exam, and I want to wish you all the very best of luck in the exam. Thank you very much.